Okay, good afternoon, everybody. Welcome to the Kings COP, Court of Protection Bitesize seminar. The key is in the name Bitesize. We're going to keep this quite short in terms of just looking at one particular case, some of the issues that come out of it, and the relevance in other cases. I'm joined today by Sophie Hurst, obviously a member of our Kings Court of Protection team, and together we're going to take you through this case of CLF, which came out last week before Mr. Justice Poole. All right, so I'm going to start by going through the background of the facts very, very briefly. So CLF has a diagnosis of a learning disability, autism, or ADHD, and possibly, the expert said, who was Dr. Rippon, named in the judgment, emotional unstable personality disorder. And as a result of that diagnosis, sometimes became emotionally dysregulated. The Court of Protection application was issued some time ago in March 2022, and some of the features of the case were these. First of all, that she required one-to-one support at all times, and that included in the community. But that she constantly absconded was the second feature. She placed herself at risk with individuals whom she'd find either outside or in particular via social media. Some of those individuals were unsavory, presented a risk to her, and she had constant different sexual partners. So the circumstances were quite stark in that sense. So the issues for the court to determine in this judgment was whether she had capacity to make decisions in respect of various issues. But I'll hand over to Sophie.
Thanks, Sam. So capacity was the key issue in this case. The parties were agreed in relation to a number of areas. They all agreed that CLF lacked capacity to conduct proceedings, make decisions about her care, make decisions about contact with others, and in relation to the internet and social media. But there were areas in relation to capacity that they disagreed on. The first of these was in relation to residence. Dr. Rippon's evidence was that CLF had capacity to make decisions about residence as long as the care provided in each residence option was the same. The position taken by the local authority in this case was that it should follow that CLF therefore lacked capacity to make decisions about residence. But the OS's view, on behalf of CLF, was that the court should find that CLF had conditional capacity, meaning that CLF had capacity to make decisions about residence as long as the care provision in each residence option was the same. The second area of dispute was in relation to sexual relations. The LA and the OS on behalf of CLF agreed that CLF had capacity to make decisions about sexual relations. The OS on behalf of CLF's mother, and the OS was acting for CLF's mother in this case because she was found to lack litigation capacity as well, didn't agree. And that position was supported by the fourth respondent in this case, or the third respondent actually, which was CLF's grandmother. The OS on behalf of CLF's mother said that essentially because CLF had been deemed to lack capacity to make decisions about contraception, it followed that she lacked capacity to make decisions to engage in sexual relations. The reason being that one of the reasons that she lacked capacity in relation to contraception was that she understood, despite being informed otherwise, that the withdrawal method was 100% effective. And the OS was arguing that CLF's lack of understanding meant that she did not understand that you could get pregnant from engaging in sexual relations or unprotected sex, which is part of the relevant information identified by JB, and therefore she lacked capacity to engage in sexual relations. The final issue was about contraception. This was perhaps less contentious. All parties agreed that she lacked capacity to make decisions about contraception, but the official solicitor on behalf of CLF invited the court to make an interim declaration only on the basis that education could be offered to CLF, which would allow her to regain capacity to make decisions about contraception. Before we go on to look at what Mr. Justice Poole actually did about those issues, we thought we'd provide a bit of a recap on some of the key cases that Mr. Justice Poole touches on in this case. Thought first just to quickly run through the relevant information in the areas that were disputed. So for residents, it's the case of LBX versus K, if you're all aware of. For sexual relations, the key case is still JB, and that's the one to look at. And for contraception, it's a local authority versus Mrs. A and Mr. A. The relevant information identified there was added to in the case of Mental Health Trust and Others versus DD, when it was decided that the relevant information should also include complications in relation to that may occur in relation to childbirth, and that should also be a piece of relevant information for contraception. I'll hand over to Sam to talk about the other. I think really this is probably the key case that is discussed by Mr. Justice Poole and comes about when he is making his conclusions on this case.
Yeah, thanks, Sophie. So in Re B, which was before Mr. Justice Cobb and then latterly in the Court of Appeal, the court was faced with some very, very similar factual facts as in CLS, insofar as that the expert evidence was that she had capacity in respect of residence, but lacked it in respect of care. At first instance, that's what Mr. Justice Cobb decided, and then the local authority in that case appealed on the basis that the judge had failed to take into account the reasonable foreseeable consequences of making that decision. And that, when I say that decision, is that it is his decision in respect of residence, that she had capacity in respect of residence, and obviously relying on Section 3(4) of the Mental Capacity Act. That was the first ground of appeal. The second ground of appeal, that it produced a situation that was irreconcilable in terms of its conflict with capacity in a different area, namely care, because the court determined in that case that Re B lacked capacity in respect of care, and that finally, that actually the practical consequence of all of that is that it would be impossible to actually care for her. So if you can imagine a situation where someone has capacity in respect of residence, lacks it in respect of care, how on earth do you deal with that? So that was the case of Re B, and what the Court of Appeal said, that what the judge was wrong to do at first instance, Mr. Justice Cobb, was to consider the decisions in self-contained silos. And this concept of silos has come up quite often since Re B. But in this case, what the expert concluded was that CLF lacked capacity in respect of care, so similar as in Re B, but then had capacity in respect of residences, as Sophie's outlined, but on a kind of caveat basis. And that caveat basis was that if the two options, or any 3 or 4 options, residential options that she was considering, met her assessed needs under the Care Act, then she had capacity. Now, bear in mind what Sophie just said, which is that in LBX, that one of the tests of, well, not the test, but one of the pieces of relevant information for residents is that you need to have a broad understanding of the care that you're going to receive in each of the type of placement. So already you've got a kind of tension as to the type of information that you need to retain. But Dr. Rippon, in this case, in CLF, was very clear that if she understood, well, she would be able to understand if her care needs were met, that piece of information, and ergo then she had capacity. We'll go on to what the judge decided, but that's really quite important in terms of these cases about inconsistent decision, this concept of silos, and not considering decisions in a self-contained way.
In relation to residents then, Mr. Justice Poole agreed with the local authority's position, and the local authority in their submissions, it's reported in the judgment, warned that the court shouldn't fall into the trap that was identified in the case of Re B. And Mr. Justice Poole concluded that CLF lacked capacity to make decisions about residents. He accepted that the OS's proposal that CLF might have conditional capacity may at first flush be an appealing one, but it was more complex than that. He said not only was there an interaction between residence and care, and that he would have to consider the compatibility of residence and care and the issues that you face with LBX, given that care is part of the relevant information in relation to residence. But he said he would have to reconcile the other declarations he'd made as well. So in relation to the fact that he'd found CLF to lack capacity to make decisions about contact and lack capacity to make decisions about social media as well. Mr. Justice Poole said that the form of residence itself in fact specifies the type of care that might be required in particular settings. So, for example, whether there's an open plan kitchen, whether it's got small multiple rooms. So how far away from P or CLF in this case would you have to be to monitor her internet and social media use? If she's having telephone contact with someone, would she be able to shut a door, for example, or would she be in an open plan kitchen? So the residence itself informs not only the care she would receive, but also certain decisions in relation to social media and internet use and contact with others. So he said it's simply not compatible. The practical implications of even a conditional declaration of capacity simply don't work in this case. So he warned against again considering relevant informational capacity decisions in silos like in Re B, and really reiterated what the Court of Appeal had to say in that case. And I think a really key issue that arises for me and appears in this case is, well, it's the interaction between residence and care. Are they in fact the same decision? Can we pull them apart at all? Should the court consider residence and care as one? Sam, I don't know whether you've got any views on that, and whether in fact that is one decision or they are two separate decisions.
Yeah, I mean, it's a very interesting point, Sophie, not least because if one looks at, say, Schedule A1 for standard authorization, the test is accommodation and care, isn't it? Automatically, there's a combination or amalgamation of the two decisions when it comes to a standard authorization. But they should be separate, because if they're not separate, we fall foul, in my view, of Section 3 of the Act, which says a decision. So the Act actually specifically says when we're looking at capacity, we have to look at a particular decision as opposed to all decisions. And if we didn't do that, there's a real argument that we wouldn't be promoting individuals' autonomy and independence. And if we go back before the Mental Capacity Act, as some of us might remember, the Law Commission, when it produced its report, said that, listen, this is the way to do it, because this is the way that promotes independence and this is the way that promotes autonomy. So in theory, they should be separate. I completely agree, but we can't consider them, as the Court of Appeal said in Re B, as self-contained silos. And we can't, because, as you say, Sophie, there's a huge connection between residence and care. I mean, if we had a scenario where the relevant information weren't mixed and there was no relevance between the two or connection between the two, then that's slightly different. But residence is always going to be connected to care, because the relevant information in residence, you need to have some kind of broad understanding of the type of care that you're going to be receiving. And when you're looking at care, you've got to understand the type, the reason for it, and what would happen if you didn't receive it. So it's artificial to say they're not connected. But the issue, I think, is whether if there is a conflict, whether practically it can be resolved. And I think, in my view, you're never going to be able to practically resolve a scenario where someone has capacity in respect of residence and lacks it in respect of care. So the practical result, I have to say, unfortunately, is that they are connected. I'm not suggesting at all that they ever should be connected, made into one decision, but practically they probably are connected. Okay, so the next thing that the court considered was in relation to sexual relations and contraception, as Sophie indicated. And in this case, the expert was pretty categoric in her view that a CLF had capacity to engage in sexual relations. And bear in mind, as Sophie's just indicated, that JB in this Court of Appeal indicated what the relevant information is in respect of engaging in sexual relations, understanding the nature, character of the act and the mechanics. The other person must consent. P must be able to say no. And in particular, of relevance here, the reasonable foreseeable consequences of pregnancy if a man and woman have sex, and obviously the risks of STIs and the fact that it can be reduced by contraception. So that's that she was absolutely clear about. But when it came to contraception, and the interviews that the expert had with CLF, it came about that she was of the clear view and very robust view that the withdrawal method was an effective form of contraception. And so for the first time, at least in since I've been practicing in this jurisdiction, we had the official solicitor acting for two individuals, and they both disagreed with each other. Because the official solicitor for mother said, well, actually, doesn't that actually demonstrate that she lacks capacity in respect of engaging in sexual relations? Because if she thinks that the withdrawal method is an effective way of preventing pregnancy, then she doesn't really understand that a reasonable foreseeable consequence of pregnancy is if a man and woman have sex. So we have this kind of tension between the two arguments that between the two official solicitors. But at the end of the day, the court, I think, accepted very clearly that the tests are very, very different in terms of engaging in sexual relations and contraception. And there was clear evidence, the judge accepted, that she understood that there was a reasonable foreseeable consequence of being pregnant. But then beyond that, that was enough for the purposes of engaging in sexual relations. But for contraception, she had that idea that the withdrawal method was sufficient, and so she lacked capacity in respect of contraception. So again, in this case, another example of a tension between two different decisions which do overlap. So one of the things that comes about, I wonder, Sophie, if you had a view about this, that is interesting that the judge did not consider residence and care determinations to be compatible, as you just outlined. But when it came to these two declarations in respect of sexual relations and contraception, he determined they were compatible. What do you think the differences are?
I mean, I think it probably comes down to that practical implications point, doesn't it? So where you practically on the ground, implementing a care package where someone lacked capacity in relation to care but had capacity in relation to residence simply wouldn't work. When it comes to contraception and engaging in sexual relations, you can easily see a situation where somebody could be supported to make decisions about contraception and supported in their choices of that, but be given then the autonomy to engage in sexual relations as they wish. So on the ground, this works as a care package. This works as a means of supporting someone in a way that the contradictions with residence and care simply don't work on the ground. And I think it also is important to remember, and it's been emphasized multiple times, that when it comes to sexual relations in particular, the Court of Protection is very keen to impress that the bar shouldn't be set too high. And if we start to break down the relevant information into these subdivisions, which I think is what Mr. Justice Poole said, is we make the relevant information so complex that it would be very difficult to foresee a situation where someone with a mental impairment or a learning disability could ever be found to have capacity, because it just becomes too complex. And then the Court of Protection would fall short of promoting P's autonomy, which at the end of the day is what the Court of Protection is all about. So I think there is key differences between residence and care and sexual relations and contraception, which make one incompatible, but one compatible with the other. I mean, looking at the case as a whole then, I think key takeaways and guidance points, we've obviously emphasised Re-B and the importance of not falling into that trap of silos. But Sam, what else do you think this case really offers us going forward in relation to guidance when we get into situations where there are issues surrounding capacity about residence and care and sexual relations and contraception?
Yeah, I think there are a couple. The first is this case is a really good demonstration of the kind of organic nature of capacity assessments, because CLF started off as lacking capacity to engage in sexual relations, and then after a period of educative work, then achieved capacity. She obviously, as the court determined, lacks capacity in respect of contraception, but as the judgment provides, she's now going to be in receipt of educative work just to deal with that withdrawal issue. And on the face of it, objectively, I think probably she will gain capacity in that area in the future. So that's the first thing, that capacity moves. It's organic. So with the right education, as you say, especially with sex, where the threshold is quite low, you can achieve capacity in the right case. I think the other takeaway is remembering the test under Section 3.4 about the reasonable foreseeable consequences of making a decision one way or the other, and that is part of the relevant information. I think that's something that a lot of us kind of overlook sometimes. So this is emphasized quite heavily by Mr. Justice Paul in this decision. The third thing is that he emphasizes, as has many judges throughout the last decade, that the list of relevant information under Section 3 is not exhaustive. So when we look at LBX and we look at JB and we look at all the other cases and REBI in terms of social media, that's not the definitive test. It's the starting point. And you've got to look at the actual factual context and then apply that and then decide whether or not you need to add to it or remove some parts of it. So, for instance, when it comes to engaging in sexual relations, there's no point considering pregnancy if you've got a relationship with two men or two women. So it's got to be adapted to the specific factual context of the case, and that's what Lord Stevens said in JB. I think the fourth point is, which is not really applicable here, but Mr. Justice Paul made reference to it in one of his previous decisions in PN of last year, which is when it comes to engaging in sexual relations, the facts will tell you whether it's going to be person-specific or act-specific. I think that's quite conceptually quite difficult sometimes to get over, because we've all been it's all been hammered home for the last decade that actually when it comes to engaging in sexual relations, it ought to be act-specific, but it can be person-specific if the circumstances are right, in terms of, say, someone posing a risk to somebody and then you look at that particular person. But in short, I think finally, the point is that when relevant information is connected, so for instance, for residence and care is a really good example, you can't consider them in self-contained silos is the first thing. But if you can distinguish the practical problems, then you might be able to achieve a situation whereby you have inconsistent decisions. But if you can't displace that kind of practical problem, then the reality is that you can't consider them as self-contained silos and you consider them as one. So those are my real takeaways. Great.
Thank you for that, Sam. Well, I think we've managed to keep it well into the bite-sized territory anyway. It's been short and sweet. But I think at this point, I don't know whether anyone has any questions they want to ask. It can be useful to ask questions in a group setting because, someone might be sat on a question and not feel confident enough to ask it. So if there are people who want to ask questions, if you perhaps put them in the chat function, and Sam will pick some out just with the time we have left. But maybe that no one wants to ask any questions in front of people. That's absolutely fine. We've popped our email addresses on the screen. So if anyone does have any questions they want to ask, please do feel free to get in touch with us, or obviously our clerks as well can make contact with us. You can make contact with us through that forum too. I hope you found this insightful and helpful. We're going to be putting on a number of these bite-sized seminars going forward. Hopefully means everyone can still have a 5 o'clock finish, which we all like. So do keep an eye out on the King's website and advertisements on LinkedIn as well. And I'm sure we'll bring you another talk very shortly. So thanks very much for joining us.
Thanks, everybody.